All right, good morning, ladies and gentlemen. State of Florida versus Glenn Stephenson. Parties announced, please.
Andrew Haig on behalf of the state of Florida.
Assistant Public Defender raising his hand on behalf of Mr. Stephenson.
Stephen Trader, Assistant Public Defender on behalf of Mr. Stephenson.
All right, Mr. Stephenson, would you mind raising your right hand to be sworn? You swear affirm any testimony given will be the truth, whole truth, nothing but the truth?
Yes, ma'am.
Very well. Thank you, sir. You can put your hand down. Okay. Anything to take up before we bring the jury in?
I don't know if Mr. Haig needs to address anything with regard to anything that happened during opening statements. Happy to address it now. Water over the bridge, really nothing. I mean, I'd ask the court to admonish Mr. Consuelo from doing that again. I'm sorry, Mr. Haig, the court order indicated that. Oh, sorry.
Yeah, I think that I made it clear that, you know, what my ruling was. I invited the counsel to provide me with any case law, anything that would potentially impact my ruling. Counsel was unable to locate such case law. Now, there was a question as to whether or not asking the officer, well, you know, when my client came in and after he was Mirandized, he spoke with you freely. I don't have a problem with that. I don't think that that's inappropriate, but that's where it ends.
We understand the ruling on it, and that will not go into any inculpatory, or rather, self-serving exculpatory statement. We will just talk about with Officer Duran and the officers who testified that Mr. Stephenson.
That he was cooperative.
That he was cooperative and freely and voluntarily made a statement, and that Miranda was administered. My concern with that is an opening statement, he's getting the benefit of that. An opening statement, he says that, you know, the state would, you know, should produce that, and now you're sort of giving that credence by saying, oh yeah, and they're gonna go on what they were in an opening statement.
I'll remind them that what the lawyers say in opening statement is what they believe the evidence will show, and what the lawyers say is not the evidence, and you have to rely on the evidence. If you would like me to give them that kind of instruction, I'm just concerned, frankly, in highlighting something, you know.
Again, and I understand that, Your Honor. You know, when I requested the curative instruction, I thought about that as well. And, you know, it just puts the state under the bus, but that's the way it happened.
Okay.
Last matter,
Yes. I speak up a little bit so we make sure I know you have your mic, they're hot mics. So.
We have a witness that we intend to call, Officer Eugene, who was subpoenaed. I don't know if he was one of the officers that was outside. I did see Duran. Duran and Williams are outside. So we have Officer Eugene on his mandatory subpoena starting at 9 in the morning.
Okay.
And I have him until 5. So
Okay.
I don't know, I'd suggest to Mr. Haig, as a courtesy, maybe to the officer, maybe to reach out to him to let him know that he is under mandatory subpoena. If I can see a copy of the subpoena, I will reach out to him.
Okay, great.
I have it here.
Great.
And he notified it, acknowledged it on June 15th.
Okay.
So I just don't want there to be any issues down the line, down the road, and where the court has to enforce the defense subpoena and issue maybe an arrest warrant or material.
No, I'm hopeful that in the spirit of cooperation, get all the witnesses here timely so that we could finish the evidentiary portion of the case, hopefully by 1 o'clock. That's the goal. Okay? All right, very well. Can we have the jury in?
Sure.
Thank you. Remember, the mics are hot, so you should turn them off when you are at.
Should we bring the jury while he's still reaching out to the detective?
I'll text him.
Yeah, Mr. Haig was, I think that's what he was doing.
William, I don't have a deadline for that. I have Duran. He has, so I have, the report's gonna need a copy of it. Okay, when it comes in, right, you can get it from him. Okay. Right about now, when he's gonna jury, just give me.
That's fine. When he walks in, he's gonna have it and he can,
Yeah, just give me a heads up. And Chris, I apologize, we had gotten that deposition very late. That's all right, he filed it, but I have a copy for the report. And as long as the court gets a copy, I'm good.
that's for your witness, correct?
No, that's for.
Oh, the one that you're talking about?
Yes,
Okay.
sir.
Very good.
I have Duran and I have.
Okay.
Judge, did you swear on the defendant? For the day? Did I miss it?
I don't know. Mr. Stephenson, did I swear you in already today?
Just early.
Okay.
I missed it. Then you missed it and I missed it.
I missed it too. All right. Everyone can be seated, thank you. Good morning, ladies and gentlemen. How are you all doing today? You know what I forgot to tell you? It gets really cold in here. So I'm glad some of you, I see you, some of you brought a sweater or a jacket, but if you really get uncomfortable, I think I have a couple of jackets back in the, okay, so let us know, okay? Because it does get chilly in here. All right. Welcome back. We are ready to continue now. Okay. Hold on. All right, state, you can call your next witness, please.
Yes, Your Honor, the state will call Detective Jarvis Duran. With your permission, and well, if anybody object to me not having my mask on?
Sir, would you please step forward, face the clerk, and raise your right hand to be sworn?
You solemnly swear affirm the testimony you're about to give will be the truth, whole truth, nothing but the truth, sir? You can have a seat.
Good morning, Detective. Do you please state the full name and occupation of the members of the jury?
Jarvis Duran, I'm a detective in Dade, North Carolina.
How long have you been assigned, how long have you been employed by the Miami-Dade Police Department?
5 years.
And could you tell them, please give the members of the jury a brief synopsis of what you've done since you've been in the, or where you've been assigned since joining the Miami-Dade Police Department?
Been attached to the U.S. Marshals Task Force, went after multiple fugitives, conducting multiple search warrants, where big amounts of narcotics were seized, firearms seized, documented gang members. About it.
What's your current duty assignment?
Same thing, Northside gang,
North side,
gang unit,
Union? And how long have you been in that position?
2 years.
Do you work alone or do you work with a squad?
I work for the squad.
Please tell us a job description of what you do in the gang unit, North Side gang unit.
Wait, say it again?
Please tell the members of the jury what your duties are with the North Side gang unit.
Duties are, we have small gang problems in the district, that overflow to the city of Miami, Hialeah, Opelika, Alpata area. We assist them. We also try to crack down on multiple shootings that you see on the news. We're part of that. We assist the general investigation unit, reference possibly knowing the victims or subjects. About it.
Were you assigned in that capacity back on December 18, 2019?
Yes,
On that date, did you have occasion to arrest a person that became known to you as Glenn Hayward Stephenson?
yes,
Do you see that individual in the courtroom today?
yes.
Would you please identify him by an article of clothing that he's wearing?
He's wearing a black, blue, jacket with a black shirt.
Let the record indicate the defendant has identified the defendant.
The witness has identified the defendant, so.
Did the defendant look the same now as he did back on December 19th?
Different clothing, but yes.
Showing you what's been marked as State's Exhibit 1F for identification purposes. Do you recognize it?
Yes,
What do you recognize it as?
the defendant,
Is this the photograph that was taken when he was booked into the Dade County Jail?
yes,
At this time, the state removed State's Exhibit 1F for identification purposes into evidence. Subject.
Without objection,
States 1F marked for ID on states 2 with evidence.
May I publish your honor?
you know,
Thank you.
I'm gonna ask the witness also, if you would, sir, you might have to just get a little bit closer to the mic
okay,
and just speak a little slower.
no problem.
Thank you so much, sir.
Let's go back to what led up to the arrest. Describe what transpired before you came into contact with the defendant.
One of my partners, who was driving an unmarked vehicle, observed a dice game that was going on, on the 49th Street and 27th Avenue behind the store. It's about 5 to 10 individuals rolling dice.
Let's stop there for a second. I'm going to show you what's been marked as State's Exhibit 1D for identification purposes and see if you recognize that. I'm not sure which way it's upside down.
But yes, I recognize the area.
Does that fairly accurately depict the area that you were in when you came into contact with the defendant?
Yes,
Statement at this time moves State's Exhibit 1D for identification purposes into evidence. Subject.
Without objection.
States 1D marked for ID from states 3 in evidence.
And publish it to the jury. Your
You
Honor.
may.
Now, Detective, with the court's permission, may you step down to point out places on the State's Exhibit? Was it 3? 3.
Sure, that would be fine,
Detective, come on down. Let me try to stay out of the way.
Your Honor, may I read this?
of course.
Can you show the?
Hold on a minute, Mr. Just let counsel, make an adjustment.
Okay, tell us where, first of all, how many people, describe what the plan was before you got to this location.
The plan was to make contact with the individuals who were rolling dice. From what we know, on multiple occasions when there's a dice game.
I'm sorry again, so sorry. I do need you to keep your voice up because you're not in front of the microphone. Thank you, sir.
So from my experience, every time there's dice games, there's usually guns involved.
Objection, hearsay,
Sustain.
move to strike.
Strike the last comment.
Had the
please.
area been scouted as far as determining that there was a dice game going
Yes,
on? And as a result of their, and describe, if you will, where the dice game is taking place.
approximately.
And where did you pull up on the scene?
I ended parking this, parking lot here.
Okay. Now, how many people were with you during the course of this operation?
I can't give you an exact number, but it was
What's-
multiple people.
Was it just the Miami-Dade Police Department North Side gang?
No, it was also City of Miami, City of Miami game.
Okay. And is that unusual?
No,
And do you work together, when you work together, do you all, ride in your individual cars?
no, we pair up due to radio problems.
Is that because the City of Miami radio can't reach Miami-Dade, and Miami-Dade can't reach City of Miami?
That's right.
Okay, so who were you riding with, if you remember?
Detective Williams.
And he is from the City of Miami, correct? Okay. Now, you said you pulled up to the, I guess that would be the south of JR's food store?
Correct.
Did you pull into the lot?
Yes,
And then were you in a marked unit or a unmarked unit?
unmarked.
Do these unmarked units have, equipped with lights so that they're not seen when they're off, but they're seen when they're on?
Correct.
Okay. And where else did, members of the combined task force, where did they go?
Everybody else drove on the street. I was the only vehicle, parked in the parking lot.
What did you do when you got there?
We're not, again, we're not getting a good audio. Perhaps the witness.
Maybe you can sit and also reposition
Resume
myself.
and
so
maybe
that
you can put that in a way.
You may want to go over it that way. Okay.
All right, and
Now
that
you're
way
supposed to-
all the jurors can see,
Oh,
and
yeah.
let's do that.
Show the members of the jury again where you parked.
Right on the south of the food store, the parking lot.
So you pulled into the parking lot?
Yes,
Were you driving or was Detective Williams?
Detective Williams.
Once you got there, what did you do?
Exit the vehicle, basically right behind the store. I had a clear sight of the dice game that was going on.
And the dice game again was, so you're here on the west side, southwest side of the building, correct?
Yes,
And then,
southeast side.
okay, southeast side, you're right. So then I'm on a highway. So what did you do when you got there?
Exited the vehicle and I began walking towards the individuals.
Were the individuals in the dice game, would that be on the sidewalk along here?
Yes, it was on the sidewalk, almost in the middle of 49th Street between
Okay.
26th and 27th.
And who got there? Did you have your blue and red lights, or did Detective Williams activate his blue and red lights when he pulled into the parking lot?
I don't recall if he did or didn't.
Okay. Was the car, when the car was parked here, did they have a clear shot at where the individuals were shooting dice?
Yes,
Okay. So you then went where?
I then began walking to the vacant lot towards the individuals. And then that's when
We'll get to that. How many people did you observe on the sidewalk playing dice or observing?
I can't give you an exact, like I said, maybe 5 to 10 people.
Okay. Once you saw those 5 to 10 people, was that the focus of your personal observation as you walked around the corner of the store?
Yes, until something else happened.
Tell us what happened.
I observed the individual walking westbound, along the street.
Okay.
He had like a white hoodie on. Then there was like a table, a chair, right around this area here. That was flipped upside down, the chair. He then lifted the chair and I observed him grab something from his waistband and throw it under the chair.
What did you do after you saw him throw something under the chair?
He then casually walked back towards the sidewalk and I walked to the chair, directly to the chair.
Was there anybody else around the chair when you went up to the chair?
No,
When you saw back up a second, who do you identify? Can you identify the person you saw walking toward the chair?
at the moment or today?
No, today.
Yes,
And who was the person?
the defendant.
And is that the same defendant you identified earlier in court?
Yes,
Was he the only one? Was the defendant the only one around the chair at the time you approached?
yes.
Now proceed with what you saw him do after you observed him walking and throwing something under the chair. Oh, excuse me, 1 second. Could you tell what color the object was that he pulled and put under the chair?
Due to the lighting, no, I can't give you the exact color. It was dark in color, but that's about it.
What did you do after you saw the defendant throw something under the chair?
I walked to the chair, I observed what it was, and then I advised one of the coworkers to take him into custody.
Okay. Detective, I'm going to show you what's been previously marked as 1C for identification purposes. Have you take a look at it and see if you recognize it.
That's the chair that was taken up.
Okay. Is that show the chair as you saw it when you arrived on the scene?
Yes,
Your Honor, at this time, the statement is it fairly accurately depict the position of the chair as you found it.
yes,
At this time, the court would move what's previously been marked as State's Exhibit 1C into evidence.
Without objection.
May I publish, Your Honor?
Well, first, let Chris just give you the
Oh,
exhibit
sorry.
number.
Let me get this back. Mark it.
Page 1C, mark right, on space 4 in evidence.
You may publish.
Thank you, Your Honor.
Mhm.
Detective, after you saw the defendant walk up and put something from his waistband under the chair, did you go to the chair?
yes.
What did you find there?
It was a black handgun. It was inside of a black latex glove.
Was there anything else under the chair or in the area?
No,
Was that firearm eventually seized?
yes,
Showing you what's been marked as State's Exhibit 1A for identification purposes, I'm going to ask you to take a look at it and see if you recognize it.
yes.
What do you recognize it as?
The same handgun that I found on the chair.
Was the chair moved in order to take this photograph?
Yes,
Is this photograph using a flash or natural light?
naturally.
May I publish to the jury, Your Honor?
Was it introduced?
No, not yet.
Okay.
This is 1A, moving it into evidence at this time.
No objection.
Without objection.
Page 20, mark right, on space 5 in evidence.
And I published to the jury, Your Honor.
You may.
Is the location of the gun as you found it, although it's a little blurry on State's Exhibit 4, can you show the members of the jury where you came across the gun?
Under this chair,
In the shadow, can you see it under the chair?
no,
Did you search the, even after you moved the chair, did you search the area?
yes,
Did you find anything other than the gun and the glove?
no,
Did you ever lose sight of the defendant after you saw him put the gun under the chair until he was detained and placed under arrest?
no,
Was there anyone else around the chair at any time while you were there, other than police officers and detectives?
no,
Mhm.
Showing you what has been marked as State's Exhibit 1B for identification. I'm going to ask you to take a look at it and see if you recognize it.
yes,
What's the difference between that? Is it a fair and accurate depiction of what you saw that night?
yes,
What's the, at this time, the state would move State's Exhibit 1B into evidence?
Without objection.
While he's marking that, Detective, what is the difference between that photograph and State's Exhibit 5?
has a flash,
Which one?
the next one,
The next one? So the photographer used a flash to photograph
yes,
States 1B marked for ID and state 6 in evidence.
it? Had this firearm been moved at all from the time that you approached the chair to the time this photograph was taken?
no,
Is that in the exact resting place it was when the firearm was seized?
yes,
And you indicated the chair had been moved. Had it been under the chair or next to the chair?
under the chair,
Permission to publish, Your Honor?
You may, sir.
So State's Exhibit 5, I believe it was the firearm just in, I guess I call it ambient light or natural light, whatever light was there, and this one is with a flash, correct?
yes,
Detective, are you the lead in this case?
yes,
Any and all reports come to you?
yes,
Did you submit the gun for testing to see if it was operational?
yes,
Did you submit it for DNA and for fingerprints?
yes,
Did you receive any positive reports on DNA or fingerprints?
no,
Overruled.
Objection confrontation.
Overruled.
Detective, for the members of the jury, what are latents?
latency, like fingerprints,
Are latent fingerprints that are done in a controlled setting, like when you're being booked, or are they lifted from possibly things on a scene? If you know.
I, from what I know, it's lifted off of items,
Thank you, Your Honor. Pen to the witness.
Cross.
Morning, Detective, how are you?
I'm good.
Good. So I want to talk about your experience with your unit in the department that you work for, correct?
Okay.
So you've been with the Miami-Dade Police Department, you said earlier, about 5 years.
Correct.
Right, at the time of this incident, you were there for about 4, right?
Correct.
And not only are you in the game unit, working with the North Side District of Miami-Dade Police Department, you're also a field training officer, right?
Yes.
And as a field training officer, you're trained to help out and advise other officers how to be a cop.
Yes.
You basically train them how to spot potential crimes.
Yes.
You teach them how to talk to witnesses.
Yes.
You teach them how to collect evidence.
Yes.
You teach them how to document that evidence too.
Yes.
And you advise them and you teach them the best practices for each.
Correct.
Now, like we talked about, you're in that game unit, right?
Yes.
All right, that game unit is a proactive unit.
Yes.
All right, you're looking for crime, right?
Yes.
You work and operate in dangerous neighborhoods.
Yes.
These are like high crime areas like we talked about, right?
Correct.
There are areas where there are lots of robberies,
Yes.
areas where there are lots of shootings,
Yes.
areas where there are lots of guns.
Yes.
The game unit, like we talked about earlier, they work with other police departments, right?
Yes.
One in particular, as it relates to this case, is the City of Miami Police Department.
Yes.
They got their own game unit.
Correct.
Now, both gang units, they work in joint operations.
Do we work in one?
Right, you both work in joint
Yeah.
operations, the both departments that is.
Yes.
And before these joint operations, you usually have like debriefings before heading out into the field.
Briefing.
Or briefing, excuse me. Sorry about that, I put the D instead of, but briefings nonetheless. You have them before you go out in the field, right?
Yes.
There's a plan
Yes.
and you guys execute that plan together.
Correct.
I want to talk about, just generally speaking, body worn camera, okay? Just
Okay.
body cams in general.
Okay.
The Miami-Dade Police Department has body cams.
We do now, yes.
Body worn cameras are standard issue equipment.
Correct.
Body worn camera are important investigative tools.
Yes.
Body worn cameras can be used to protect officers.
Yes.
Body worn cameras can be used to prosecute the guilty.
Correct.
And body worn cameras can be used to protect the innocent.
Yes.
Your police department, Miami-Dade, had body cams back in 2019 in December.
Yes, but my unit didn't have the cameras.
I understand that, but your department did, right?
Correct.
Now, the proactive unit of the gang unit doesn't wear body cam,
We do now.
but not then.
Correct.
But the Dade Police Department did have body cam back then.
Yes.
Want to talk about this planned operation that you had in this. So you both, Miami-Dade Police Department and the City of Miami Police Department, you all met at the North Side Station.
Yes.
And there, like we talked about, generally, in these gang unit proactive details and all that work that you do, there was a briefing as to what you were going to target in this particular case.
Yes.
Now, there was a particular area, maybe not a specific location, but an area that you were targeting, right?
Yes.
That's the Brown sub area.
Correct.
All right, the Brown sub area is a pretty large area. It's between Northwest 62nd Street and Northwest 42nd Street, right?
Approximately, yes.
And then the other cross streets, we're talking about Northwest 33rd Ave and Northwest 18th Ave.
Correct.
So it's a pretty big area.
Yes.
Now, within that Brown sub area, we're also talking about, can you describe to them what that is? Is that a gang, the Brown sub area?
No, it's just name of a specific area. It's actually called
Okay.
the Brown Sub.
But within that area, do they have like a gang there, the Brown sub gang?
We do have a gang that goes by 12-4 or Brown Subs,
Right.
in that particular area.
So we have these gangs, but just to be clear, Mr. Stefferson is not a registered gang member, right?
No,
He's not a known gang associate.
no.
I want to talk about where you're at. Now, you mentioned that you were with Detective Williams, right?
Yes.
There was another officer that you were in the car with that day though too, right? You were with Detective Pinckney.
Yes,
So Detective Pinckney and yourself and Detective Williams, you're all in that unmarked police car together.
correct,
You said Detective Williams is driving.
yes,
Now, they're with the City of Miami Police Department,
yes,
and you had heard that there was a dice game at the corner store, at JR's Food Store, and like we talked about, that's off Northwest 49th Street between 26th and 27th Avenue, thereabout.
well, it wasn't at the corner store, it was at the vacant lot.
Well, the vacant lot, to be fair, is part of the JR's Food Store, right? It's right there.
It's on the same block, yes,
Okay, it's on the same lot. So y'all go there, the JR Food Store, right?
yes,
And then you say Williams was driving and he parks the car, and that was on the south side of the building, right?
yes,
And then as Mr. Hayes showed everybody on that map, we're talking about, I mean, so the JR's Food Store, you would have parked right here, right? On Northwest 27th Avenue, just directly below the JR's Food Store, you would have parked in that parking lot, right?
yes,
Now, you mentioned there were about 5 to 10 guys there that were playing dice,
possibly, yes,
and according to you, what, they had their backs to you?
for the most part, yes, most of them have it back, so,
Now, in that vacant lot, and just like we showed in the depiction here, and that was State's Exhibit 3. There's that big tree line, right? Big canopy.
he has a picture, yes,
All right, so we've got big trees and we got debris everywhere too, right?
not big debris, just paper, cans, yes,
All
debris,
right. And not only that, we got maybe some furniture. We're talking about maybe a chair and a table too.
yes,
All right, and the chair, it's more like a love seat than anything, right?
it's a single seat,
Yeah, big love seat. Like just a single
Yeah.
sofa.
kind of like this chair right here, it's a single seater,
Okay, so a single seater. You're thinking more like the chair that we have in court today that looks like a computer task chair.
right, same, about the same size,
All right. I want to talk about what you claim you saw. Other unmarked police cars, they roll up on that dice, right?
yes,
And by roll up, that means driving up, right?
yes,
And then rolling up also means maybe jumping out of the car and getting out.
yes,
So you're out of the car. Now you're about, is it fair to say 30 to 40 yards away from where these men were playing dice? Give or take.
yeah, give or take,
And you claim that just as these unmarked cars are rolling up, Mr. Stefferson, he peels away from that group
yes,
and then he walks towards that area where the table and the chair is at.
yes,
And then you claim he got something from his waistband.
yes,
Now, he lifted up the chair a little bit, right?
right,
He pushed it up a little bit. Must have lifted it up and had to push it up, right?
maybe lift it up a little bit,
Okay, he lifts it up a little bit, and then, according to you, he throws an unknown object underneath that chair.
Yeah.
And the chair, as it laid and as you saw it, it was upside down.
yes,
Now, you couldn't see what it was at that time. You claim he threw, right?
I couldn't see the object, no,
Use the cell phone?
yes, oh, no, actually, I used digital camera,
Okay, you got a cell phone on
yes,
you? Smartphone?
yes,
Take pictures too,
yes,
with or without flash?
yes,
But this case, you used a standard issue police camera or something from the north side police station?
Yes, our unit has a camera.
Do you remember the make and the model of the camera that you used?
It's a Nixon, I don't know the model.
Okay, so you're saying you used the camera to take these photographs, though?
Yes,
Not a video camera, you're talking about, what, an old school digital camera?
digital camera.
Okay. Now, let's talk about what you say you found underneath that chair. Under the chair, you say that the gun was, well, you found a black latex glove, and inside of that glove, there was a firearm, right?
Yes,
Now, the butt of the gun was sticking out of the latex glove,
yes,
just as it's depicted in this photograph, right?
yes,
And the gun had a magazine in it,
yes,
and afterwards, there must have been at some point that you ejected the cartridge, right?
yes,
That you must have then, and the cartridge being, or really the magazine, excuse me, ejected the magazine from the gun, right?
yes,
And then inside the magazine, you must have noticed that there were bullets inside, right?
yes.
And then you noticed that there were maybe 12 bullets in all?
I don't remember the count, but there was rounds inside of the gun.
I'm sorry, sir, you just, yeah, just a little bit close to the mic there, okay. Could you repeat your response?
I don't know how many rounds, but there was rounds inside of them.
Thank
When
you.
you're collecting evidence, do you fill out a property receipt?
Yes,
And evidence like this, where there's a firearm, there's a magazine, there's bullets,
yes,
you fill out a property receipt, right?
correct,
We're looking at your property receipt, refresh your recollection as to how many bullets were in that gun?
yes.
Commissioner Roach?
Sure.
Thank you. Take a moment to review the document, don't read it aloud. And then when you're done, turn it over and let me know when your memory is refreshed. Memory refreshed?
Yes,
How many bullets did you find in that gun?
12,
9mm?
yes,
So the handgun itself, it was a Taurus Millennium G2,
yes,
and like we talked about, the 12 bullets,
yes,
one magazine,
correct,
and then each of those items, you mark them in order, 1 to 3.
yes,
I want to talk about DNA evidence. DNA evidence are pieces of us that are left behind when you touch something, right?
yes,
Something that you handle, right?
yes,
Something that you physically touch.
yes,
DNA can come in many forms,
yes,
like blood,
yes,
like sweat,
yes,
like skin cells.
yes,
And as much as you know, and using your common sense, DNA is unique to everybody.
correct,
It's just like a fingerprint, right?
correct,
And essentially, no two people's DNA is the same as far as you know.
correct,
Maybe if you're twins, if you're lucky.
possibly,
Now, the DNA that's left behind, or let me back up. Are you familiar that convicted felons must register and have their DNA on file?
yes,
And that's on a statewide database.
correct,
So are you familiar that if you're arrested and if you're booked in a jail, your DNA is also collected?
I don't work corrections, I wouldn't know that.
So you're not aware of that.
No, I know fingerprints are taken, I don't know about DNA.
Now, with what you're familiar with, DNA can be searched, right?
Yes,
DNA it can be cross-referenced.
yes,
And if you're suspected of committing a crime, DNA is involved, you can submit that DNA for testing.
correct,
Now, I want to make sure I heard you right. Did you say on direct examination that the gun was submitted for DNA testing?
I believe it was, yes,
So it's your testimony that it was submitted for DNA testing.
I believe so, yes,
Now, not only is it that you fill out that property receipt for a gun. See that, show that you collected it. If you wanted to submit something for testing, there's something called a laboratory analysis request, right?
Right,
All right, in this particular document, you're talking about submitting a piece of evidence for analysis, for testing.
right,
And the gun was tested in this case, as far as you know, for that it worked,
correct,
that it's an operable gun.
yes,
All right, in order to do that, you got to check off certain boxes.
yes,
And there are a lot of boxes that are on that form, right?
correct,
All right, in order to test the gun, to make sure it's a working gun, you check off the box for firearms, right?
I would have to see if I receive what I checked off, so.
Or the lab
The
analysis
lab
request.
analysis,
But
right,
it just knowing if you're familiar with the document, because you must have done hundreds of these, right?
right,
When you submit a piece of evidence, like a firearm for testing, you got to check off the firearm box, right?
right,
Okay. There's another one too that's called NIBIN. You got to check that off too.
yes.
All right, NIBIN, can you explain to us what that is?
Not even as a database that, when patients are collected on scene, it's able to basically have like its own fingerprint in a sense. The striking of the hammer on the patient gives it a specific marking that makes it come back to a specific gun.
And it's your testimony that you submitted that gun for DNA testing.
Yes, I believe so.
That correct, Louis?
You may.
Thank you. Take a look at the document. Borrow my pen. And I want you to look at your laboratory analysis request form and explain to all of us and circle for us on that form where it says that you submitted it for DNA testing.
I didn't submit it, you know.
Keep the pen, keep the document handy. I have more questions. Now, you chose not to check off that box.
Chose maybe I forgot.
You're the lead detective in this case.
Yes,
You're a field training officer. You know how to collect and document evidence.
correct.
Did your pen run out of ink?
No,
Now, in order to do fingerprint testing, same thing. You gotta check out the box, right?
yes,
But let's dive a little bit deeper into fingerprint evidence. Just like DNA, fingerprints are unique to all of us.
Objection, Your Honor, all outside this officer's area of expertise.
As far as you know,
I'm gonna overrule if you know.
just as far as you know, fingerprints are unique to everybody,
yes,
similar to DNA.
yes,
And fingerprints are left behind on the objects that you touch,
possibly, yes.
as far as you know.
Well, it has to be a smooth surface.
Maybe just like I'm tapping my thumb on this podium,
Yes,
and if it's conducive to picking up that fingerprint, right?
right,
Smooth surfaces. Now, the act of me putting my finger on this podium, that's called a latent fingerprint, right?
yes,
And a latent fingerprint can be a full print if I happen to roll it, right?
possibly, yes.
It could be a partial print if I happen to just graze that podium, right?
Again, Your Honor, outside this.
Yeah, I think we're getting a little bit beyond. Sustain on that. Go
If you
ahead.
know.
Again, Your Honor, stated objection.
Sustain, counsel.
So at least you know about full fingerprints, right? You touch something and it's a smooth surface, you leave it behind.
Again, Your Honor, the statement that I object.
Yeah, sustain, counsel.
As far as you know. Or if you know about standard fingerprints.
Objection, Your Honor, same objection.
Move along, counsel. That's sustain.
So are you familiar with or know that if a convicted felon is convicted of a crime that they leave behind as part of a judgment and sentence? A standard set of fingerprints.
Objection, Your Honor.
If he knows, you can answer.
If you know.
Ask and answer.
Well, no, sir. If you know it's a different question, listen to what the question is.
Repeat it, please.
Yes, sir. When you're a convicted felon, you're convicted of a crime, you leave behind, and you must leave behind your fingerprints, part of the judgment and sentence, if you know that.
Yes.
Now, that standard set of fingerprints, if you know, can be cross-referenced and analyzed from latent fingerprints. Just so long as you know, that's all I'm asking.
Objection, Your Honor, again, outside of the area of expertise.
I think it's pretty general knowledge. If he's aware in law enforcement, you can answer the question.
Yes.
So let's go back to that lab analysis request form. You did not check off the box for fingerprints.
Correct.
Magic?
Sure.
Let's talk about what happened after the arrest.
After the what? Sir?
After the arrest.
Okay.
So he was arrested, Mr. Stephenson, and he was taken back to the station.
Yes.
He was taken there for an interrogation.
Yeah.
Before interrogating him, you read him his Miranda rights.
Correct.
It's the Miranda rights that everybody's familiar with, right?
Correct.
All right, so you have a right to remain silent.
Yes.
You have a right to, and these are the rights that you explain to him, right?
Right.
You're informing him of his rights.
Yes.
That's what you got to do under the law, right?
Yeah.
So it's his right to remain silent, like I said.
Yeah.
It's that anything that he says could be used against him.
I read it off the paper, so.
I'm just going over the rights with you, one by one.
But I read it off the paper. I don't know if you're missing anything or when you say it.
I'm happy. You want me to refresh your memory as to the Miranda rights? I'm happy to. I have the paper.
Objection, argumentative.
Yes, sustain.
Would you like to see, or would it help refresh your recollection to see the Miranda waiver form that you read to Mr. Stephenson?
Would I like to see it?
Yes, if it would help refresh your memory as to what you read to him.
Show it to me.
Sure. May I, Judge?
Sure.
Take a look at the document. Please don't read from it. And when you're done refreshing your memory, just turn it over, please. Ready, sir?
Yeah.
So you went over all the Miranda rights with him, right?
Yeah.
And after you went over all of the rights with him, he freely and voluntarily spoke to you.
Yes.
And he was cooperative.
Yes.
No further
Do
questions?
you want to pick the document back up?
Yes, Your Honor.
Very good, thank you. Okay. Counsel, any redirect?
Yes, Your Honor, if I may.
Sure.
Detective, I'm going to show you what's been marked as State's Exhibit 1, for identification purposes. State's Exhibit 1. Do you recognize it?
Yes.
What do you recognize it as?
Hangman.
And can you tell if this is the same handgun that was seized in this case?
Yes.
Is that a yes, you can, or yes, it is?
Yes, it is.
Okay. And how does it work when you submit the gun? Is it, I see there's a box here, who packages it?
I do.
Okay, is this the way you packaged it?
Not exactly. I guess after testing, they repackaged it.
Okay, so they put the gun inside the box.
When I submitted it, it's inside the box. Yes.
So you submitted it for NIDA, correct?
Yes.
What's NIDA?
It's a database where able to, collect basically a fingerprint from cases. Not a fingerprint, but a specific striker.
So, in other words, they tested to see tool marks when the gun is fired, correct?
Correct, or possibly related to another shooting or another incident.
But also gives you the background on where the gun came from, correct?
Yes.
One moment, Your Honor.
Okay.
Nothing further, Your Honor.
All right, very well. Thank you, sir. You are excused. Mhm.
State will call Detective Williams.
Okay, Detective Williams. Sir, would you please step forward, face the clerk, raise your right hand to be sworn?
You solemnly swear firm testimony about to be able to be true, full truth, nothing but the truth, sir? I do. You can be seated.
Thank you, sir. Just keep your voice nice and loud if you would.
Yes, ma'am.
Thank you.
Detective, please introduce yourselves to the members of the jury.
How you doing? Good morning. My name is Detective Williams. I'm with the, currently assigned to the City of Miami Gang Intelligence Unit
How long have you been with the City of Miami Gang Unit?
since January of 2019, for about 2.5 years.
Were you so employed, were you so assigned on December 18th, 2019?
Yes,
On that date, did you have occasion to participate in, for lack of a better term, an operation that was conducted by your unit?
yes,
Was that operation a joint Miami-Dade, City of Miami operation?
yes.
And how do you determine where you go once you are conducting this operation?
It's based on, there's like certain hot spots within Miami-Dade jurisdiction. At the time, the county was lead, so they just advised us of different coordinates of where we would be saturating, what areas.
Does somebody scout areas to determine where you are to respond?
Yes,
And on that date, do you know how many cars were involved?
how many detective cars were involved? I don't recall.
Okay. Are they undercover cars or marked units?
Unmarked units.
And who did you ride with on that particular day?
On that day, I rode with Detective Duran and Detective Pickney of the City of Miami Police Department.
And what's the reason why City of Miami is, also has a Miami-Dade police officer in the vehicle?
Due to the radio communication, we was able to hear what the county, since we were in the county area, Miami-Dade, we was able to hear what was going on with off of Detective Duran's radio.
So is it true to say that City of Miami is on different frequencies than Miami-Dade?
We had different radios, different systems, correct, at that time.
On that date, did you have an occasion to respond to Northwest 27th Avenue and 49th Street?
Yes,
Had you been given any information prior to going to that location?
most of the subjects, on the sidewalk, on the south side of the street, loitering and playing a game of chance.
When you say loitering and doing a game of chance, what kind of game? Are they playing roulette? What are they doing?
Shooting dice.
And why is that a concern to tip the gang units off of both jurisdictions to respond to that area?
Because
Objection.
If he knows.
Objection relevance. Objection. for-
I'm gonna sustain, try to rephrase that, counsel.
Okay, why did you respond to a dice game?
It was via radio where one of the detectives announced that stated that it was several individuals shooting dice on the sidewalk.
During the course of your career, are you aware of instances where that has resulted in violence?
Objection,
Uh,
4-3, objection.
yeah, I'm gonna sustain counsel.
Detective, I'm going to show you what's been marked as State's Exhibit 3 and ask you, if I get it upside right, if you recognize it.
Yes,
What do you recognize it as?
the incident location where we responded to.
Can you show us who was the driver of the vehicle you were in?
I was the driver.
Can you show us where you, how you drove up to the scene?
I parked south of the store, inside of the lot as well, where the subjects were playing like a game of chance. They was actually just north of us. So when I got out the unmarked vehicle, where I walked from south and north.
Okay, and where were you when you could see the individuals playing rolling dice or playing a game of chance?
So if this is the front of the store and they was over here gathering, I parked here and we walked up from south and north.
Okay. What did you see as you turned the corner of the food store?
As we got in the vehicle, what I observed was a group of individuals. At which point I observed the defendant then turn around with his head down, not observing me walking myself.
Speculation.
Overruled?
Let's break that down, Detective. When you reached the corner of the store, you said you saw the people on the sidewalk rolling dice, correct?
Yes, sir.
Were they all congregated in that specific area?
Yes, sir.
And after you turned the corner, by the way, this is sort of which came first, the chicken or the egg. Did you drive to your spot first, or did the people roll, and other detectives roll up along the sidewalk first?
Well, at the time, once I exited my vehicle and got around the corner of the store, that's when I saw the other unmarked vehicles in front of the subjects who was down on the sidewalk.
So, and I'm not sure if I understand. So when you got around the corner, had the unmarked cars on the street in front of the people playing rolling dice, did you see them pull up?
Yes, sir.
So you got there first. You parked your car before they pulled up.
Yes.
Okay.
Yes, sir.
And you turned the corner in time to see them pull up.
Yes, sir.
Tell the members of the jury what you saw as you rounded the corner of the food store.
As I rounded the corner, as the other detectives exited unmarked vehicles, I then observed the defendant then turn around, walking southbound with his head down, never making eye contact with us, walking from south and north. Then he was fumbling with the unknown object at the time to go to a couch that was in the field and place the unknown object at the time up underneath the couch that was in the field.
Okay, so let's break it down again. The individual that peeled off from the group playing dice. Did that happen as the other police cars rolled up?
Yes, sir.
Did those police cars, were they undercover vehicles?
Unmarked, yes, sir.
But did they have the ability to put red and blue lights behind their grill or whatever on their visor?
Yes, sir.
When they pulled up, were those lights on?
Yes, sir.
And it was after they pulled up or approached with their identifying lights that you saw an individual peel off from the main group.
Yes, sir.
Ultimately, did you get a chance to see that individual?
Ultimately, yes, sir.
Do you see him in court today?
Yes, sir.
Could you identify him by the article of clothing he's wearing?
Yes, sir.
Would you please do so?
Yes, sir. He's wearing he got what is that? A blue blazer with a black undershirt. Okay.
Indicating the defendant for the record.
So reflective.
Will you please recount for the members of the jury what you did, not anybody else, what you did as you rounded the corner and saw him, the defendant, tuck his head down and peel off from the crowd? What you saw and what you did.
Okay, when I saw once he turned around and peeled off from the corner away from the detectives who was just north of him, Turned around, fumbled an object, placed the unknown object up underneath the couch, and then walked back to the crowd as if like nothing happened. At which point, we went to him, as Detective Duran went towards the couch area. We actually detained him. Everybody was detained. And then that's when, pat down was conducted on him, at which point, a bag of what you call weed.
Hold on a second.
Sustain,
I'm just trying to.
strike the last comments by the witness.
Okay, let's take a little shorter segment. So you saw the defendant put his head down and walk away from the crowd.
Yes, sir.
Did he make eye contact with you?
No, sir.
What did you see him do?
That's when he placed the unknown object up underneath the couch that was inside the field.
When you say, where did you see him take the item from that he put under the sofa or chair?
It was like from his like waistband area.
How far away were you from Detective Durant?
We was pretty much close.
Okay.
Okay.
Were you like next to each other or just separated by a foot or two?
Probably about a foot or two.
Was there any conversation that took place between you and Detective Duran when you saw the individual pull something out of his waistband?
Yes, we actually pointed towards the couch area. And that's when the detective went direct.
What you observed, sustain.
Detective, I'm going to show you what's been marked as State's Exhibit 4. Do you recognize this? However you hold it where you want.
Yes, that is the couch.
Okay, when you say couch,
That was on the field.
was it a couch or a stuffed chair? You can give you a call.
No, I don't recall anymore.
What did you do after you saw the defendant pull something from his waistband and place it under this object?
I went directly towards the defendant.
What did Detective Duran do?
Detective Duran went towards the couch area that was in the field.
Okay, what did you do when you reached the defendant?
Well, everybody was detained, but once I reached the defendant.
All right, can we stop for a minute? I need to see you all here
Separate.
with the court reporter. Thank you.
Detective,
Hold on.
sorry.
Right, we're good?
Detective, who is the lead in this case?
Detective Rand.
Did you transport the defendant?
No, sir.
Do you know who transported the defendant?
No, sir.
Is. There's no further questions. Thank you, Detective.
Oh, Cross.
Morning, Detective Williams.
Good morning, how you doing?
Wow, okay, so you work for the city of Miami, correct?
Yes, ma'am.
And at the time of the incident, you said you're in the gangs unit?
Yes,
Or are
ma'am.
you still currently in the gangs unit?
Yes, ma'am.
And you were talking about how on this particular day, it was you and Miami Dade that was working together.
Yes, ma'am.
And there's about 6 detectives in your unit,
It is 6 detectives.
6 detectives.
Six
And
detectives,
one
one
sergeant.
sergeant.
So 7.
Yes.
Okay. And that doesn't count the gang unit of Miami Dade that was also working with you that day, right?
No.
So there's at least, do you know how many are in the Miami Dade unit?
No.
Were there several of them?
Yes, ma'am.
And on this day, you guys were doing sweeps,
Yes, ma'am.
essentially just going around to do the high visibility where you drive through neighborhoods.
Yes, ma'am.
And these are the types of neighborhoods that are high crime areas.
Yes, ma'am.
And when you do these sweeps, there's no particular target or person that you're looking for, right?
No, ma'am.
More of a proactive sort of patrol that you're doing.
Yes, ma'am.
You're essentially going through areas looking for crime.
High visibility, you can say.
Sorry?
I'm sorry.
High visibility, we can have visibility.
High visibility, yeah, right. And when you're on a proactive unit, you're driving around looking to see if people are committing crimes and things like that.
Yes.
Okay. You're basically, I guess, surveying people in these neighborhoods.
Yes, ma'am.
Okay. Now, this particular sweep of this area has happened at nighttime.
Yes, ma'am.
It was already dark outside.
This instant, yes, ma'am.
Okay. You guys had been doing the sweeps all day, but when by the time you got here, it was around 7-ish.
Yes, ma'am.
And in this area, the 49th Street and 27th Avenue, there's a corner store.
Yes, ma'am.
And on one of the sidewalk areas, that's where the men are playing dice.
A game of chance, yes, ma'am.
And when you get there and you see them playing dice, you don't see any like guns out visible, anything like that.
No, ma'am.
You don't see any like violent gang fights or anything like that.
All right, no, ma'am.
Okay, they're literally just playing dice.
Yes, ma'am.
And you said you parked your car on the south side?
Of the store, yes,
The
ma'am.
south side of the store. And when you're approaching the men, you're approaching from south to north.
Correct.
And there are other detectives who are on the north side.
Correct.
And those detectives, it's the same unmarked cars, right? It's unmarked cars for those detectives as well?
Yes, ma'am.
Okay. And there's more than one detective in those cars as well?
I don't know who rode with who that day. There was several unmarked vehicles there.
Several unmarked
Yeah.
vehicles there, okay. So several officers there.
Yes, ma'am.
And they're also approaching as well from the north
Yes, ma'am.
on this one group of men.
Yes, ma'am.
And when you are doing this detail, you're wearing your tactical vest
Yes, ma'am.
that say police.
Yes, ma'am. On the front and back.
Go ahead,
On the front and back, it states police.
front and back. And you also have your firearm.
Yes, ma'am.
And on direct examination, you say that you see the defendant walking away from the group of the men who were gambling as officers are approaching.
Yes, ma'am.
And you say that he's fumbling as he's walking away,
Yes, ma'am. Walking southbound.
walking southbound. He turns from the group, maybe takes 2 or 3 steps, and then that's when you start seeing the fumbling.
Yes, ma'am.
You don't see what's actually in his hands though, right?
No, ma'am.
And the field that he's walking towards, about 10, 15 feet away.
Yes, ma'am.
You said you see him place something on the ground.
Yes, ma'am.
And after he places that thing on the ground, he doesn't run away.
No, ma'am.
He returns to the area where all the men are playing dice.
Yes, ma'am.
He returns to the group that all the officers are walking towards right now.
Yes, ma'am.
You said you're riding with Officer Duran
Detective Duran and Detective Pickett.
and Pickett. Okay. One moment, Judge.
Mhm.
Nothing further.
Very well, thank you. Any redirect, counsel?
No, Your Honor.
Very well, thank you so much, sir. You're excused.
Thank you.
Mhm. Counsel?
Your Honor, at this time, the state will rest.
Just waiting for Robert to come back in because I am going to give you a few moments break. He's out there with the witness. Okay, maybe so. Okay. All right. No, that's fine, no problem. All right, ladies and gentlemen, we're going to take about a 10-minute break. I'm going to ask you to leave your notepads at your seats. Which courtroom are you staging in?
We're in the
Fourth three, I think it is. But again, you can all move about comfortably. Just remain vigilant at your comfort level. And we'll have you back in about 10 minutes. Please do not discuss this case. All right, thank you.
All right.
Chris? All right, everyone, please be seated now. Thank you. All right, defense, I am going to take your first motions, please.
Yes, Your Honor, for our first-
Would you, Dimitri, or if you don't mind coming to the podium so we can hear you.
At this time, the defense moves for our first judgment of acquittal, even in viewing the evidence in the light most favorable to the state. The state has failed to establish a prima facie case for the charge of felon in possession of a firearm. Your Honor recalls the testimony. No officer actually mentioned ever seeing Mr. Stefferson with the firearm in his actual possession. And the officer also admitted on cross and direct cross-examination that at no point did he get any sort of evidence linking the defendant to the firearm in this case. And we would also like to just renew all previous motions and objections, and we ask that Your Honor find a judgment of acquittal in this case.
All right, very well. State?
Your Honor.
Mm-hmm.
As far as judgment of acquittal, Your Honor, in the light most favorable to the state, it is abundantly clear that there was testimony that they saw the defendant walk toward the chair. They saw him reach into his waistband, something dark or black, put it under the chair, and then go back and rejoin the others or walk toward the others. Detective Durant said he never lost sight of the defendant. Detective Williams said that he went to the chair, and both Detective Williams and Detective Duran indicated that there was nothing else under that chair, and that and they did testify that he reached in the waistband and placed something under the chair. That being the firearm, I think as far as the judgment of acquittal, there is sufficient evidence for the state to meet its burden.
All right. Question I have with regard to the stipulation. That stipulation should be read and should have been read, frankly, before the state rested, although it's a stipulation of fact.
I don't think, Your Honor, Ms. Etienne's judgment of the will include any argument as for stipulation.
The charge is possession of a firearm by a convicted felon, and that's one portion of it. Although it's kind of unique in this sense because the defendant disclosed it during jury selection. So I would ask that the court bring the jurors back in.
I just technically, in order to ensure that this is done properly, I think that the jurors, there has to be a stipulation read to the jurors regarding that fact. And then, and I would allow the state to reopen for that limited, but I don't think it impacts my ruling on the motion for judgment of acquittal.
I don't believe so, Your Honor. It does not, Your Honor. But what I would suggest instead is we can, when we're charging a jury, and read the instruction that it is stipulated. That is an argument that we're not making for our case, in the state's case in chief.
It should be in the state's case, Your Honor, and I apologize that it's so abundantly clear during jury selection.
I agree. I think it's just an oversight, but I think technically it should be in the state's case in chief. Even though it's a stipulated fact, I just think it's a lot cleaner, and that's how I have done it.
Understood.
So I need first, I can also rule on the first motion for judgment of acquittal. Having heard the argument of the parties, the court is going to deny the defense first motion for judgment of acquittal based upon the standard that's to be applied.
And what language would the court be reading the stipulation or would the state?
Well, I would be reading, you would present the stipulation, but I'd like to just have the language fleshed out and everyone agree on it.
Sure.
And then I would give an instruction. Okay,
When the jury's charged.
right, but exactly. So, so the stipulation should read, the parties in this case, I like parties rather than attorneys
Okay.
or lawyers. Are you okay with that?
Parties is fine.
The parties in this case have stipulated to the fact,
Shorthand.
okay, no. That-
Stipulated to the fact
that Mr. Glenn Stepherson, the defendant in this case, is a convicted felon.
you want to go over just which the instruction they will be reading to them?
Now, this is the instruction that I read. When the parties agree, this is 2.3. When the parties agree that certain facts are true, that is called a stipulation of fact. You must accept stipulated facts as having been proven. However, the significance of these facts, as with all facts, is for you to decide. In this case, the stipulated fact that you must accept as true is that Mr. Glenn Stepherson, the defendant in this case, is a convicted felon.
That's, I think, agreeable language, Judge. I'm reading directly from Brown versus State that deals with old chief. There's something very similar, that the element of the convicted felon status, element of the crime as proven, which is proven by agreement of the parties in the form of a stipulation.
Okay, I like that, actually.
Mr. Hayes, you want to see the?
I like that better because this is an element of the crime, and there's a paragraph in here, the significance of the facts. I don't even think that applies.
Are you saying the public defender's language is better than Your Honor's language?
Well, I'm saying that in the standard instruction on stipulation, there's a sentence here that says, however, the significance of these facts, as with all facts, is for you to decide. Well, you see, that's not really true.
I agree. Because I think this language, and I'm happy to show it to Your Honor, Brown, that talks about The stipulation in the language there.
On a convicted felon case,
Correct.
right.
Okay.
I'd rather use that. I think it's,
Deviating from the standard instruction, giving the instruction as was in Brown.
But I think the standard instruction, if I may, it's like a stipulation.
stipulate to an element of the crime.
Which is possession of, that is a convicted
The
felon.
parties have stipulated to an element of the offense of the crime, an element of the crime charged here.
As stipulated.
Read that to me again,
Yes,
counsel.
sir.
I don't like deviating from the Supreme Court.
I don't want to deviate significantly from this.
I understand, and the language that I'm reading directly from Brown versus State, and this would be 719, so it's like 882 at 889 of the opinion. Quote, if the element of convicted felon status is established by stipulation, the judge may thereafter instruct the jury that it can consider the convicted felon status element of the crime as proven by agreement of the parties in the form of the stipulation. End quote.
Can the jury,
I'm happy to repeat.
go ahead, one more time, the jury what?
Pardon me. The judge may have to instruct the jury that it can consider the convicted felon status element of the crime as proven by agreement of the party in the form of a stipulation.
I think that the standard instruction is clearer and simpler than that instruction.
I think I have to hybrid this because of this nuance that, when you talk about stipulated facts, you're not talking about generally an element of the crime. This is unique because one of the elements of this crime is the convicted felon status. So
It could be even simpler. The defendant is charged with carrying a concealed firearm, by carrying a weapon.
possession of a firearm by a convicted
Thank
felon.
you. And the element of the defendant being a
Convicted felon,
has been stipulated to by state defense.
all right.
Sorry, really quickly, me and Michael got to just realize something, in regards to the judgment acquittal. We actually have a final issue that I don't believe it came out in anybody's testimony that the incident happened in Miami County. I don't think any of this is out there.
They didn't ask for a statement of particulars of the address. The court can take judicial notice of it, and if they did not.
Well, there was testimony about Brownsville and
Nobody
Look.
said it's in Miami County.
understandably so. However, I would not grant a judgment of acquittal on that, just based upon the testimony and the inferences I think logically that can be drawn. I am going to allow the state to reopen their case, limited to things. Okay. You need to have a witness that can testify to that fact or provide explanation given the description and the location and, already testified to. And second would be the evidentiary portion of the stipulated fact. Now, would the parties prefer, and I'm thinking about that on the stipulated fact, that I read that to the court, to the jury,
Stipulation, yeah.
that I read that to the jury?
Yes.
Okay. And that should be actually included as a court exhibit. Well, actually, it could be a state exhibit, and it would be introduced as a state exhibit in their case in chief.
Can you get back here for 2 minutes?
Okay.
Can you get back to the courthouse in 2 minutes? Oh, I'm sorry, you're on your way though, right? I can hear the background. How far is that from here? Okay, thank you. Yeah. Okay. I know. Okay. Let me call the next page, the closest one. Thank you. All right.
Let me tell you the instruction I would read. Um, when the parties agree that certain facts are true, that is called a stipulation of fact. You must accept stipulated facts as having been proven. In this case, the parties have stipulated that the convicted felon status element of the crime charged in this case has been established. Well, I could say has been proven.
Has been established by stipulation, something like that, has been established.
I already said it's stipulated.
Yeah, it's stipulated, the court, the state believe that it should make mention of the fact that, it has been stipulated to and therefore proven that the defendant is a convicted felon.
Has been established and proven
That the defendant.
beyond every reasonable doubt.
That the defendant is a convicted felon.
Right, okay. Has been proven. That's it. I don't think I have to keep saying is a convicted felon because I said. When the parties agree that certain facts are true, that is called a stipulation of fact. You must accept stipulated facts as having been proven. In this case, the parties have stipulated that the convicted felon status element of the crime charged in this case has been established and proven.
Other than, you say beyond a reasonable
I
doubt,
can say beyond every reasonable doubt.
otherwise with the state, without a condition, the state,
Okay.
well,
All right, yes, go ahead, counsel.
Yes, Your Honor, so Detective Eugene, I just wanted to inform the court in that way we're not having to, I guess, deal with objections as they come, that, under the Florida Evidence Code of 9612, I have a copy for Your Honor, and state as well.
I have it, I know what it is, go ahead.
That section 3 says, it's about the mode and order of interrogation and presentation, and this is in regards to being able to cross-examine Detective Gene, and the reason I say that is because he falls under 90.612 subsection 3. Leading questions should not be used on direct examination of a witness except as may be necessary to develop the witness's testimony. Ordinarily, leading questions should be permitted on cross-examination. When a party calls a hostile witness, an adverse witness, or a witness identified with an adverse party, which I think is what it is here, a witness identified with the party that is setting my client to the crime, interrogation may be by leading questions.
Your Honor, the hostile-
Maybe, this is all within the court's discretion.
Yes, Your Honor.
Okay,
And because it is the city of Miami and Miami-Dade Police Department, and the lead is with Miami-Dade Police Department, they are the lead is with Miami-Dade Police Department as well, and the lead is saying that my client committed a crime, he's a part of that department, he's a part of that unit, he's an adverse party.
yeah, and he's an adverse party. However, if you would like to proffer, you know, I mean, you're calling this witness is not going to be any surprise to anyone, right? If you would- What's that?
I learned of it today.
Okay, well, would you like to proffer? Because here's how I feel it's more appropriate to handle. You can start your examination, and if it becomes apparent, even though technically he's an adverse party because he happens to be a member of the department that was involved in the arrest of your client, that does not, in my opinion, right now, since I have not heard anything in and of itself, allow for leading questions. So if you want to either proffer or start the examination, and, you know, I'll allow some flexibility in doing that because I think it's important to be able to direct, just like we had with the last witness, being able to direct a witness if it's already understood the purpose and through proffer as to what the witness, what you intend to call the witness for. So let's not make that a big surprise.
Yes, Your Honor, and I think that what the court is saying, that it doesn't appear at this point that he's a hostile witness, and what I'm saying is that the rule is saying he doesn't have to be hostile.
I know what the, right, it could be, there's alternative options, not just necessarily hostile, and I agree with you.
Yes.
I'm not disagreeing with that. It's still discretionary in terms of how you're gonna question or handle the witness. So, again, if you want to proffer what the purpose of the witness is and what you intend to elicit from the witness.
Yes, Your Honor, I can proffer. I attempted to elicit from Officer Eugene what he observed that day. His observations of my client as it relates to my client discarding what everyone's saying is a firearm.
Okay, so,
I'm gonna go a little bit into his background, and I always start with a little bit of background.
all right, and how does this officer, how is he involved in this whole situation?
What, as Your Honor remembers, the two officers we saw were the officers from the south side.
Right.
Officer Eugene's from the north side.
Okay,
He approached from the front.
he approached from the front and they approached a different direction. He approached though, and according to the testimony I heard, he would be in a group that came just after the witnesses who testified arrived. According
According to that.
to them. So he's going to testify from your, I'm already inferring from your proffer that he was there first.
I believe he does actually.
Okay.
I believe he does say that he's one of the first.
All right, and he is going to refute in his testimony having any of those types of observations based upon his vantage point?
Oh, no, this is his observation. He's gonna say his observations. He also says that he believes my client took something out of his waistband. It's just different.
It's just what?
It's just different than what the other officer says.
Okay.
It's a very different situation. So I just wanted to get that out.
Mr. Hague. Okay. Again, so we're not having any surprise here. Mr. Hague, have you seen the deposition? Do you know what?
I don't have it with me because I wasn't, I went to the office.
Okay. Shall we make you a
I
copy?
can read it all. By the way, Detective Durant says he will be here in 20 minutes.
In 20 minutes.
That was a head start.
Okay.
And I don't know when,
All
I
right.
hate to have the other one, on his way from Homestead.
Right.
I've been, computer.
All right, thank you. Everyone can be seated. All right, thank you, ladies and gentlemen, for being so patient. The court's going to allow the state to reopen their case in chief for a limited purpose. Counsel?
Thank you. Detective Williams,
Yes, sir.
this was a joint city of Miami, Miami-Dade Police Department operation, correct?
Yes, sir.
And you had your city of Miami, and you had Miami-Dade police officers running with you, correct?
Yes, sir.
Did all the facts that have been discussed occur in the city of Miami?
No, sir.
Did they occur in Miami-Dade County?
Yes, sir.
So, it would be the county Miami-Dade Police Department that would have jurisdiction over the, incident and then whatever pact the two departments have. Is that correct?
Yes, sir.
But it was Miami-Dade County.
Yes, sir.
Was there any additional questions, cross-examination, any questions? All right, very well. The witness is excused. Thank you so much, sir.
Thank you, sir.
All right. And ladies and gentlemen. Thank you, sir. There's one additional matter. Ladies and gentlemen, when the parties agree that certain facts are true, that is called a stipulation of fact. You must accept stipulated facts as having been proven. In this case, the parties have stipulated that the convicted felon status element of the crime charged in this case has been established and proven beyond every reasonable doubt. State?
Yes, ma'am. Yes, that's,
The state is going to rest at this
yeah,
time?
I'm sorry, state rest.
All right. Now I'm going to send you to lunch. Okay? So this is what I'm going to ask of you. I know it's an early lunch. We'll probably take a little snack later on anyway. So I'm going to send you to lunch until, let's say, 12:50, 10 minutes to 1. It'll be a comfortable lunch. If you wish to leave the area, you can do that. Again, we have lunch places available in the building. We just opened up some places, right down the street. And you're welcome to go there as well. It's imperative, please, do not do any research or try to gather any information. That's not evidence. The only thing that is evidence is what you received in the courtroom from the witness stand and under oath. And that's all you can consider in ultimately reaching your verdict. Don't talk about the case with each other, with anyone else. No investigation, no research. If you see any of us outside of the courtroom, we're going to continue to ignore you. Please don't approach, try to ask questions. Even a hello can be misinterpreted. All the parties are advised to please maintain, again, no contact or communication with any of our jurors. Should you have an issue, question, problem, anything, that's the person to go to. Our trusted bailiff, Robert, okay? And he'll do what he can to help resolve whatever concern you might have. All right. So I'll see you back. Robert will let you know outside where to meet up again at 12:50. Okay? Very good. Enjoy your lunch. Thank you.
All right, for the jurors.
All right, ladies and gentlemen, everyone be seated. Thank you. Thank you, ladies and gentlemen. We are going to resume at this time. The state had rested and now defense.
Active board.
Okay. So would you please step forward, face the clerk, and raise your right hand to be sworn?
I'm sort of testimony about the culture, not about the church.
Come on over here and be seated. Oh. Detective, I notice you're wearing a hat. I want, ladies and gentlemen of the jury, that the detective is not disrespecting the court in any way, and he'll continue to wear the hat. Thank you.
Good afternoon, Detective. Can you please state your first and last name for the jury and, well, please tell me work for.
Yes, sir. George Eugene, I work on.
Okay, but I have to ask you, sir, if you would, to speak up a little louder, if you would, and also slow down.
Yes, ma'am.
Excellent.
Detective George Eugene, I work for Miami-Dade Police Department,
Thank you, sir.
And how long have you worked there?
since 2006.
In December of 2019, were you in any particular unit in the Miami-Dade Police Department?
Yes,
What unit was that?
North Side District Gang Unit.
And do you recall an incident that took place on December 18th of 2019?
Yes,
And this happened in the area of Northwest 49th and 27th Avenue, right?
yes.
So that day, what exactly were you doing?
We were partnered with City of Miami gangs. We were just conducting a normal saturation detail on our areas of concern.
And were you targeting any specific person?
No,
What actually led you to 49th Street and 27th area?
my partner was conducting surveillance in the area. He observed a large crowd gambling, and he directed our attention to that area.
And were you riding alone that day?
No,
And were you in a police marked vehicle or unmarked?
unmarked.
Unmarked vehicle. Okay. Do you remember who you were riding with?
Yes, Detective Marisa from the City of Miami gangs.
Just him?
Possibly two of his City of Miami members also.
So about 4 of you in that one car.
Yes.
So when you get to 49th and 27th, what do you observe?
Observed the group of males gambling.
And were you the first to arrive and get a visual of this group?
Yes,
And did you ever drive past the group in that vehicle?
yes,
And when you drove past them, do you know if they saw you?
yes.
And how do you know that?
Because when I drove past them, I had the City of Miami officer parked several yards away to obtain their attention. It's something normal that I do.
So when you got to the scene, and saw them gambling, did you notice anything else? Were they just gambling?
They were gambling, but then once I took their attention away, I remained in the vehicle to allow the other detectives to start approaching, which is our normal practice. And once the other detectives got close enough, I exited the vehicle.
And what did you see when you exited the vehicle?
Once I exited the vehicle, I observed the defendant walking away from the crowd, and that got my attention.
And when you saw the defendant walking away from the crowd, did you see anything in his hands?
No,
And was there ever a time when you were able to see what exactly was in the defendant's hands?
no.
And where did he walk to?
He walked south away from the crowd towards a tree,
And when he got to that tree, what did he do?
went into his waistband, removed an unknown item, and dropped it on the ground.
And so you see him just place it on the ground, right?
Yes.
Did you ever see him lift anything?
No,
Only to confirm? And really quickly about the field that you saw, this field, is it a clean field? Is there stuff on the field, like trash, debris, furniture? What's there?
Yeah, there's a couch there. It's a field where just people just hang out and it's be there.
Okay, all right, thank you. Thank you very much.
In cross?
Yes, Your Honor.
Mhm.
Detective, what is your current duty assignment?
I'm sorry, what was what?
What is his current duty assignment?
Homeland Security.
Okay. Looking at what's in evidence as State Exhibit 3, do you recognize it? Where was the dice game going on?
And just keep your voice up. I know because you're turned, so the microphone's behind you.
Okay, so where did you, when you pulled up, where did you go?
Down here, I passed the resident funnel so you can see, and I parked.
Did you have lights on in your car? I mean, not headlights, but the blue and red lights?
No.
Were you also aware that as part of your task force, Officer Williams and Detective Williams and Detective Duran were participating?
Yes.
Do you know where they went?
I believe it came from behind on foot.
Okay. Do you know if when they, did you see where they parked?
No, I didn't.
Do you know whether they had parked before you pulled in or were you not focused on that?
No.
You,
I'm not sure if they parked before I pulled in.
Okay.
I just waited until I saw them physically there before I exited the building.
now where approximately was the, did you see the defendant take something out of his waistband and put it on the ground?
Not far from the crowd, and took several steps, maybe 5 yards.
Was there anybody else anywhere near where he put down whatever it is, the object he put down?
No.
Did you have a chance to go up and view the item that was found at that location just yourself?
No.
Did you ever see the firearm that was recovered in this case?
Yes, I did.
What, did you see it after it was recovered?
Yes, after.
Showing you State's Exhibit 1. You recognize this as the firearm that was recovered?
Yes.
Okay. Thank you, sir. Who approached the defendant after when people moved in?
I believe I approached him while I allowed the other detective to see what he discarded for himself.
Did you see anything else on the ground?
No, he had walked back towards the crowd and I approached him.
This is State's Exhibit 4. Do you recognize this?
Yes.
And do you know where in relation to this the gun was found?
No.
Mm-hmm.
When you saw the defendant reach into his waistband and retrieve something, what was your vantage point? Were you looking at him straight on, from behind, from the right side, from the left side?
I was looking at his left side.
So you were looking at his left side. Your view would have been like this to him.
Yes.
And can you stand up and describe or demonstrate what you observed the defendant do?
Going to find his waistband, remove an unknown item, and toss it around.
And can you see what color that item was?
No.
Thank you. No further questions.
Any redirect? Mm-hmm.
Detective, so you were on the northbound side, is that correct? Approaching from northbound, while the other officers were coming from south,
No, I was coming from the east.
coming from the east?
Yes.
Okay. And all of you were approaching at the same time?
No, I remained in my vehicle because that area is, it's a high violence area. So I know they would stay focused on my vehicle till they know who was in that vehicle. Once the other detectives began to approach
Yes.
and they had a vantage point, then I exit my vehicle.
Okay, so while they're approaching, you get out and you start approaching too?
Once I get out, the defendant immediately walked away as I began to approach because I had my tactical vest on, then they knew it was the police.
And then you had contact with him first?
After he returned from the tree, from the chair.
Yes.
Yes,
Okay. And the group was still there
yeah, the group was still there.
as the officers were approaching from both where, I believe Detective Duran was coming from and while you and the officers in your vehicle were coming towards them as well? The
Yes.
group stayed there?
Yes.
Moment. And about the object that you saw earlier, you stood up and you said that he stood up, you saw him go in his waistband and he placed something on the ground?
Yes.
Okay.
All right, thank you, sir. You are excused. Thank you.
Thank you.
Okay. Robert, if you'd come right back in, that would be perfect. Thank you. All right, ladies and gentlemen, I'm going to ask you to leave your notepads at your seats. I do need to address something with the attorneys without you present. It's going to take a couple of minutes, not very long. I'm going to ask you again, do not discuss the case. Just leave your notepads here. Robert's going to take you across the hall and we'll bring you right back in in 5 minutes.
All right, for the jurors.
Okay. Ladies and gentlemen of the jury, both the state and the defense have rested their case. The attorneys will now present their final arguments. Please remember, what the lawyers say is not evidence. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the opponent has spoken. For the state. Mhm.
Good afternoon, ladies and gentlemen. First of all, I'd like to thank you for responding to your summons to come down to court. It is one of the three big civic obligations you have: voting, jury service, and military. And I'm preaching to the choir and thanking you for coming down here because you're here. This is this case of the state of Florida versus Glenn Scott. A relatively simple case. It involves a single charge of possession of a firearm by a convicted felon. Now, you heard from the members of the joint task force that were all with the Miami Police Department gang unit and the Miami-Dade Police Department gang unit, who combine for saturation, stops, whatever you want to call it. And it's because they're trying to chill hotspots so that every neighborhood is safe for its residents. And again, this isn't a case where they come jumping out of their cars with guns blazing and everything else. It's kind of in slow motion. They pull up, they kind of watch what's happening. And there was never a gun wrong in this case. Well, we rephrase that, I'll get back to that in a second. There isn't a specific location that they respond to on a regular basis. Their places are scouted and they are sent to those locations in order to prevent any violence. And you heard testimony that Detective Eugene, who's now with Homeland Security, and Detectives Duran and Williams approached from different angles. The Detective Eugene, let me get mine. Detective Eugene said that Detective Eugene said that he came down, pulled up around 49th Street, went ahead of where the group was gathered for the gambling to let the other cars come in behind him. Detectives Williams and Duran testified that they came down 27, but past 49th and pulled into the food, JR's food store. And that they actually arrived a couple of seconds before the officers on 49th Street got out of their vehicles, because when they pulled up, they had a chance to get out of their car and walk around the corner of the building. And that was their vantage point to see the defendant break off from the group of males that were potentially the target and walk away from him. And they all saw him go by the area of the chair, take, one says a dark object, one says an unknown object, out of his waistband and put it under the chair. It was from different directions, they had different points of view, but the bottom line is that either they saw a motion to the waistband or they saw a black object he pulled out of his waistband and put it under the chair. They all testified that there wasn't anything else there but that firearm partially covered by the glove. They identified the person who they stopped. This is a booking photo. It is an offender, and they identified the offender. They told you about, they identified the chair, and they said it was placed under the chair or close to the tube. Then they said, well, we moved the chair before we took this picture. This picture is in the natural light. And then they said, then they used a flash and they took a similar picture and there's the gun. The testimony, you heard the detective of the testimony of these defendants, these witnesses, that after they saw him place the gun under the, or something under the chair, that he turned around and walked back toward the group of individuals that the police were stopping. And that makes sense, because now he's gotten rid of the gun. He can sit there and chat with the police all day long. He's not going to worry about it. But when the police first arrived, got rid of the gun, put it under the chair. There is no, controversy as to whether or not it's a firearm. The firearm expert testified that, the detective testified that this is the gun that was found. And the firearm expert testified that this is a fully functional semi-automatic pistol, a 9mm with live rounds. He also told us that he used to do crime scenes. And when he would process crime scenes, done it thousands of times, you process things for prints. And it's very difficult to ever get prints off of the gun. Again, the only thing under the chair was the firearm. There is no question as to another element. The crime charge is possession of a firearm by a convicted felon. We know it's a firearm, and we know the defendant is a convicted felon. So those two come out of the equation. What you all are to decide is whether or not the state has proven beyond a reasonable doubt that the defendant possessed or exercised dominion and control over a firearm. And that is taking it out of his waistband and putting it under the chair. That's possession, that's directing it, that's moving it. He was the only one in that area when the officers pulled up. And they were all consistent in the fact that they saw the motion, or they saw an object, and they saw where he put it, and they recovered it where he put it, and there was nothing else there. Ladies and gentlemen, there can be no viable verdict other than the fact that the defendant is guilty of possessing a firearm by a convicted felon. Listen closely to the judge's instructions. Those are what you are required to follow in your deliberations and what the state must prove. The state accepts that responsibility, but analyze the evidence. Thank you.
All right, thank you, counsel. For the defense.
Members of the jury, at the beginning of this trial, my co-counsel told you that this was going to be a case about big and little lies. And now, at the end, we know that what he said was true. See, the state has the burden to prove to beyond and to the exclusion of each and every reasonable doubt that Mr. Stephenson possessed a firearm and that he's a convicted felon. Now, we know that they have failed to meet that burden. The only thing that they have proven here today are the things that we didn't dispute. The fact that he's a felon and the fact that it's a gun. But they had to prove that Mr. Stephenson possessed it, that he had this gun at some point, that it is in his possession. And the reason we know that they failed to do that is because reasonable doubt can be found in three places: the evidence, the conflicts in the evidence, and the lack of evidence. And the state is resting their case purely on the testimony of officers, saying that they saw Mr. Stephenson put something in that field under the chair. So let's talk about the officer's testimony. You heard from all the officers today, and you see they had all decided on the big lie. Mr. Stephenson took something from his waistband and he put it under the chair. But they failed to confer, bless their heart, on the little details. You see, when it came to the details of how the gun got under the chair, how it even got to the area that everyone's talking about, that's where their story started to differ. And that's where the little lies came out.
I'm gonna object to the, language.
I'm not overdoing it. Go ahead.
Now, according to Detective Williams, that was the second officer that heard from, he sees Mr. Stephenson fumbling with an object as soon as Mr. Stephenson turns around. And then he sees him walk and place it under the chair. But according to Detective Duran, Mr. Stephenson gets all the way to the chair, picks it up, and tosses it under. Detective Duran and Detective Williams are walking up from the same car in the same path, watching Mr. Stephenson. And they have conflicting testimony. You get a toss, you get someone who actually says that they see something before he even gets there. That is conflicting evidence. That's reasonable doubt. And now let's talk about the biggest conflict. Detective Duran. Detective Duran got on this stand and told you when he was talking to the state that he sent the gun to get tested for fingerprints and DNA. And it wasn't until my co-counsel caught him in that lie that he said, no, I didn't. When my co-counsel had to show him the actual report that he filled out, where he had to admit to you that he had just lied to you when speaking to the state. Comes to the jury, it's like when you go to a restaurant and order a whole soup. If the soup comes back with a fly in it, you don't take the fly out of the soup and then continue to eat it. You throw the whole thing away. If a witness, the evidence for the state is going to sit there and lie to you, you don't ignore the one lie that he was shown to have told you. Throw his whole testimony away. And then you have Detective Eugene. Detective Eugene, who the defense called. Remember in Wadir, jury selection, when we told you we don't have a burden, we don't have to show you a single piece of evidence, we don't have to call a single witness, but we had to call Detective Eugene for you to hear how he describes how the gun got under the chair. When asked, did Mr. Stephenson ever pick up the chair to put anything under it? He says, no. It's just coincidentally the two officers who have been riding together all day saw him pick up the chair. And let's talk about vantage points because the state talked about that. So you have, at this point, you have officers coming from the south, the north, the east. The officers coming from the south, Detective Duran and Detective Williams, they both say they see him bend down, pick up the chair, and toss it down. But then Detective Eugene, who we had to call, said, he never picked up the chair. I saw him reach into his waistband, just kind of place it down. You see, the officers conferred on the big story. The fact that probably his gun, so we're gonna say that he took it from his waistband and put it there. But the devil is in the details. The details are those little lies, and these details, these little details, are significant. This isn't like they had a difference about the weather, or they had a difference about someone's clothing. This is what they say they saw, and this is how they're saying that the gun was supposed to have made it under the chair. That's why these details are important. It's not just big picture. And the fact that these details differ are conflicts in the evidence, and that's reasonable doubt. Now, the state would like you to believe that Mr. Stephenson is responsible for a gun that is found hidden in a field of garbage and discarded furniture. And they even showed you a picture of this field. This is the big recliner type chair that the gun was found under. Look around it, there's a table, there's trash bins overflowing. You see debris everywhere in this dark field in this high crime area. So they're saying that discarded in this field of garbage in a high crime area, an area where it is not unusual for crimes to be committed, an area where it's not unusual for officers to see guns. So if they're going to say that finding a gun on the ground in this kind of area where it's common to see guns belongs to Mr. Stepperson, when no one can tell you that they actually saw it in his hand, then they better bring the evidence to show it. And they didn't. Members of the jury, not a hair, not a fiber, not a strand of DNA connects Mr. Stepperson to that gun. And we know they have the capabilities to do it. They have the capabilities to test it. We even found out that there's someone named Jennifer Hackey who works in Leighton Prince. She signed a property receipt, but we have no idea what she did.
Oh,
What she found, or better yet, what she did not find. The state tried to say that, well, sometimes it's hard to get prints on the gun. Members of the jury, the state could have brought Ms. Hackey to tell you anything about what she did and why she had the gun. And remember that the person that did come in, Mr. Rossi, Officer Rossi, he said, yeah, sometimes it's hard to get prints on a gun, but it's not impossible. Nobody even bothered to test it. Nobody even bothered to look. Ask yourself why. Why didn't he even bother to check the box to get them to look? Because he knew the prints were going to be there. That lack of evidence, that's reasonable doubt. You also didn't hear from anyone who tried to test the gun for DNA. Now, this gun wasn't just by itself, it was in a latex glove. Detective Duran, of course, admitted that he never sent it to DNA after Mr. Consuegra made him admit it. So there's a glove. What goes in a glove? A hand. And latex is a non-breathable material. So possibly sweat could exist inside this glove. Skin cells could have gotten off inside of this glove. But you don't know that because the state never brought any evidence of DNA testing. Why not? If they are so sure that it is him, why not get it tested? Why not bring you the scientific proof to back up testimony that conflicts with each other to show you that that gun belonged to Mr. Stepperson? Because it's not his. And that lack of evidence, that is a reasonable doubt. Now, DNA and fingerprints could be on the glove, the gun, those 12 bullets, the magazine. None of that got bothered and tested. You better believe if DNA evidence did exist, the state would have rolled out the red carpet for that witness to get them up there and tell you all about how they tested it. They would have told you all about how they ran it in the system that everyone says exists, the system that everyone says that felons are in a database, and they would have compared it and they would have told you that it belonged to Mr. Stepperson. Instead, we are here because the officers felt like maybe Mr. Stepperson was in possession of the gun that none of them actually saw in his hands. But the state doesn't get to prove their case with maybes. There is nothing to corroborate these inconsistent stories. The officers even admit that they're a proactive unit, right? They admit that they are out there looking for crime. They're literally doing surveillance. Do you have any surveillance? The officer said that Miami-Dade County, we have body cameras. The department has them. They are literally walking up on people looking for crime, and there is zero reporting at all in a proactive unit. If the officer had a cell phone, he took a picture of the gun. If you see someone doing something wildly suspicious, everyone from all these angles is supposed to see something. Why not go, I should probably report that. And this is out in front of a corner store. You didn't hear any testimony that anybody went to that corner store to try and see if video surveillance exists. Why would they? They got the big lie together. They had decided that the gun was Mr. Stefferson's. Problem is that they haven't brought you any evidence to prove it. Members of the jury, that is a lack of evidence. That is reasonable doubt. And the story that's being told, it just really doesn't make sense. If someone has a gun and is a felon, and they see cops drive by, eyeballing their big group, why not walk away completely and just disappear into the night? It's dark outside. It's not a well-lit area. Everyone's talking about it. Why not just go away? How does it make sense that cops are coming that you see all these cops coming, so you walk away. They're coming from the north, the east, the south, coming at you, and you're like, you know what? I'm gonna go back. I'm gonna go back and make sure that I have interaction with cops. Members of the jury, oftentimes when something doesn't make sense, it's because it's nonsense. You cannot believe that story. That is reasonable doubt. Now, you also heard from officers that Mr. Stefferson went to the police station and he cooperated with the police. That they asked him, they told him you have the right to remain silent, and he agreed to speak to them. Why would he cooperate? Members of the jury, the state has the burden to take you all the way from the presumption of innocence that they started with, all the way to an abiding conviction of guilt. It cannot waver. It cannot vacillate. You have to have an abiding conviction that he is guilty of these charges. And they have to make sure that you don't even have a single reasonable doubt. I just gave you at least 5. And there may be others that you yourself are thinking of. It doesn't have to be the ones that I discussed. It can be ones that you saw throughout the trial that make you waver, that give you doubt, that is reasonable. Why are there still holes at the end of this trial? Why are there still questions at the end of this trial? It's because they have not met their burden. The evidence does not add up, and it is because he is innocent. When you go back into that deliberation, I want you to look at all of the evidence, better yet, all of the evidence that you don't have, and all of the evidence that doesn't make sense and that contradicts each other. And think about all the evidence that nobody even bothered to get. And I ask that you deliver a verdict that reflects that, a verdict that justice demands. Because although the state got up here and said this is a simple case, this isn't simple. It's important. It's important for Mr. Stefferson to review the evidence and ask you to return a verdict of not guilty, because he is not guilty.
Thank you, counsel. Rebuttal close.
Your Honor, members of the jury, this is a case of common sense. It is, you heard from 3 different detectives who told you what they observed, they told you what their job was, they told you what they were trying to do, and they drive up on the dice game. They weren't there targeting the defendant. They were targeting the dice game. And use your common sense. If the defendant is with the group with the dice game, he sees a police car roll up and he knows that he has a gun in his waistband and he knows that he's a convicted felon. So what would be his first thing to do? Get rid of the gun. So he goes over a few steps, and by the testimony of all 3 detectives, including the one that the defense called, all say the same thing. Judge Diversion.
Oh,
Said all the detectives said the same thing, that they saw the defendant walk away from the group, singling himself out, reaching into his waistband, and whether it be an unknown object or a dark object, seeing them place it on the ground.
That's not really.
Ooh,
Place it on the ground. So then you walk back toward the ground. Well, what would you think would have happened if, still with the gun, he took off running across the field? That would attract attention. That would cause problems for the defendant. So the best way that you could handle it was get rid of the gun, then I can talk to the police all day long, that's complete. And that's what happened in this case. All three detectives says that even though they came from different directions, they saw him peel off, was a word used by one of the witnesses, peel off away from the crowd while the police officers on the north side, I guess, focused on the crowd. Detective, the one detective that drove his car over, the detective called by the defense, says he stayed in the car to kind of draw their attention to make it safe for the other people to approach. But he saw the defendant walk away in the area of the chair, take something out of his waistband and put it under the chair. This is the chair, and this is the firearm. Again, ladies and gentlemen, use your common sense. Is the defendant, if he's armed with a firearm, is he just going to sit there as a, 3 or 4 police cars full of gang unit detectives come up? No, he's going to get rid of it. That's what he did in this case. He went somewhere close to hide it, and he's in an open field. Although it's under the tree canopy in this picture. Let's be sure the trees grow up and not down. This is the open field. Officers Duran and Williams parked here, came to the corner, saw him in this area, the gambling was taking place here. So, was the defendant going to run across here to go hide the gun or to escape? Did he know here? Oh, by the way, the other detective was in his car right here. So we went to the closest place for cover to get rid of the gun, and that is the shade. And I'm not going to go over again. There's no question that that is the gun that was recovered. No question that it was a functioning firearm, according to the firearms examiner. No question that no question that witnesses saw the defendant place an object under the chair. It was recovered and tested. Use your common sense, ladies and gentlemen. That's the one thing you don't check at the door. When you go back to deliberate, what makes more sense? That the defendant would break away from the crowd and just kind of pretend to do something when he didn't have anything and then come back? And what are the chances that right when they say that he stooped down or leaned over and placed something, they happen to find a gun? What are the odds on that? Folks, when you go in and listen to the judge's instructions, again, whether it's a firearm is not an issue, and whether the defendant is a convicted felon is not an issue. It comes down to whether or not the defendant exercised control. I mean, they don't have to see him physically with the gun. If they see him reach for something and, put it down and what's there is a gun, he's exercising control. It could be on his person, he could be moving it. All those are covered in the jury instruction. So again, ladies and gentlemen, please use your common sense. And remember the testimony as far as the defendant peeling off, putting something down, detectives moving in. Detective Duran said he focused on where the defendant put it down. Detective Williams said he focused on the defendant. Duran found the gun. We have it in property. And I ask you to return the only verdict that jives with common sense, and that is that the defendant is guilty of possession of a firearm by a convicted felon. Thank you.
all right. Thank you, counsel. Members of the jury, you have now heard all of the evidence in this case, as well as the final arguments of the lawyers for each side. It is now my duty to instruct you on the rules of law that you must follow and apply to arrive at a verdict. You, as jurors, are the judges of the facts, but determining what actually happened in this case. That is, in reaching your decision as to the facts, it is your sworn duty to follow the law I am now going to define for you. You must follow all of my instructions as a whole. You have no right or authority to disregard or give special attention to any one instruction or to question the wisdom or correctness of any rule of law I state to you. Accordingly, you must not substitute your own notion or opinion as to what the law is or should be. It is your duty to apply the law as I give it to you. And again, ladies and gentlemen, I mentioned this earlier, you will get a copy of the jury instructions as well as the verdict form to take with you into the jury room during your deliberations. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give to you. Glenn Hayward Stepherson, the defendant in this case, has been accused of the crime of possession of a firearm by a convicted felon. To prove the crime of possession of a firearm by a convicted felon, the state must prove the following two elements beyond a reasonable doubt. One, the defendant Glenn Hayward Stepherson had been convicted of a felony. Two, after the conviction, Glenn Hayward Stepherson knowingly owned or had in his care, custody, possession, or control a firearm and or ammunition. Convicted means that a judgment has been entered in a criminal proceeding by a court pronouncing the accused guilty. A firearm means any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the actions of an explosive. The frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, any machine gun. Ammunition means an object consisting of all of the following: a fixed metallic or non-metallic hull or casing containing a primer. B, one or more projectiles, one or more bullets or shot. C, gunpowder. Care and custody means immediate charge and control exercised by a person over the named object. The terms care, custody, and control may be used interchangeably. To prove Glenn Hayward Stepherson possessed a firearm and or ammunition, the state must prove beyond a reasonable doubt that he knew of the existence of the firearm and intentionally exercised control over it. Control can be exercised over a firearm and or ammunition, whether it is carried on a person, near a person, or in a completely separate location. Mere proximity to a firearm and or ammunition does not establish that the person intentionally exercised control over it in the absence of additional evidence. Control can be established by proof that Glenn Hayward Stepherson had direct personal power to control the firearm and or ammunition, or the present ability to direct its control by another. Possession of a firearm and or ammunition may be sole or joint, that is, two or more persons may possess it. Knowingly means with actual knowledge and understanding of the facts or the truth. Knowingly means an act done voluntarily and intentionally, and not because of mistake or accident or other innocent reason. As previously explained to you, when parties agree that certain facts are true, that is called a stipulation of fact. You must accept stipulated facts as having been proven. In this case, the parties have stipulated that the convicted felon status element of the crime charged in this case has been established and proven beyond every reasonable doubt. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. The state must prove that the crime was committed on December 18, 2019. It must be proved only to a reasonable certainty that the alleged crime was committed in Miami-Dade County. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? 6, did the witness at some other time make a statement that is inconsistent with the testimony he gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his testimony deserves more or less consideration than of any other witness. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4, remember the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6, whatever verdict you render must be unanimous, that is, each juror must agree to the same verdict. 7, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged or not guilty. Your verdict must be unanimous, that is, all of you must agree to the same verdict. Only one verdict may be returned as to the crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It is as follows. This is the verdict form in the Circuit Court of the 11th Judicial Circuit in Miami-Dade County, Florida, 2021. State of Florida versus Glenn Hayward Stefferson, verdict form. We, the jury, find as follows on the charge of possession of a firearm by a convicted felon. Line number 1, the defendant is guilty. Line number 2, the defendant is not guilty. Check only 1. So say we all at Miami-Dade County, Florida, this blank day of blank, 2021. This should be signed by the foreperson and also the foreperson to print their name. In just a few moments, you're going to be led to the jury room by the bailiff, which is the courtroom that we're using as overflow staging. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson will see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during your deliberations. These communication rules apply until I have discharged you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. Many of you have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave these devices on your seats where they will be guarded by the bailiff. Actually, Robert will collect them when I finish instructing you. If you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibit you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. If you wish to examine the firearm, please advise by giving a note to the bailiff and you will be brought into the courtroom to do so. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. Are there any objections to the manner in which the instructions have been read to the jury?
Not in the statement.
All right. Ladies and gentlemen, I am going to ask Luis Costa and Samilia Rodriguez to please remain in your seats. The rest of you, you may take your notepads with you. Please follow Robert and begin your deliberations.
All right, for the jurors.
All right, if you'd all be seated. Well, you guessed it, I'm sure. You were chosen as alternate jurors. I would like you both to understand, we have to choose alternate jurors in the event that any of the jurors may not be able to continue to participate at any point. Now, this was a 2-day proceeding, it's a relatively short proceeding, but so many things can happen. Your work with us, your dedication to the proceedings and to the administration of the court is no less important, was no less significant, and is recognized and greatly appreciated. You're no less important. You may feel disappointed because the final part you will not be able to participate in and participate in deliberations. But again, this does not minimize what you have done and the significance of what you have done and the sacrifices that both of you have had to make in order to perform your jury duty and to serve. We are very grateful for that. We don't function without members of our community like the two of you, who, despite the inconveniences and difficulties, put those aside and do your duty. I've given both of you, Robert's handed it to you, a small token of appreciation, certificate of appreciation, which again is just a token for the true appreciation that myself, my staff, all of the parties here have for both of you for the work that you have done and the time and energy that you have expended to do so. You are at liberty to speak with any of the parties, because at this point I am now going to discharge both of you. You don't have to. Someone may wish to speak with you. That is your prerogative. But at this time, both of you, I will discharge you again with the sincere thanks of all of us. It is so greatly appreciated, and maybe we'll see you next year when you hopefully will serve again on a jury. Thank you again. You are excused. And you can leave your notepads there.
I'll take care of it. I'll talk to you. It is freezing.
Yes.
You ready, Joanne?
All right, yes, ladies and gentlemen, we're back on the record. I understand the jury has reached a verdict.
All right for the jurors?
All right, everyone, please be seated. Thank you. Okay, ladies and gentlemen, I understand the jury has reached a verdict. Is that correct?
Yes, ma'am.
All right, and our foreperson is Miss,
Maria, Travis Gilmore.
okay, Miss Chavez Gilmore. Very good. And if you would, please, madam, would you hand the verdict form to my bailiff? The court finds the verdict form is legally sufficient. There are no errors or omissions in the filling out of the verdict form. Chris, would you please publish the verdict? I'll give you both packages here. So.
In the Circuit Court of the 11th Judicial Circuit in and for Miami-Dade County, Florida, 2021, State of Florida versus Glenn Taylor Stephenson. Case number F19-23468. Verdict: we, the jury, find as follows. On the charge of possession of a firearm by a convicted felon, the defendant is not guilty. So say we all at Miami-Dade County, Florida, this 16th day of June, 2021. Maria Chavez Gilmore, foreperson.
Does counsel for either the state or the defense wish for the jury to be polled at this time?
No, Your Honor.
All right, very well. Ladies and gentlemen, I want to take this opportunity to thank you for your time and consideration of this case. I also wish to advise you of some of the very special privileges that are enjoyed by jurors. No juror can ever be required to talk about the discussions that have occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about your work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request may come from those who are simply curious or from those who might seek to find fault with you. It will be up to you to decide whether to preserve your privacy as a juror. Robert is going to give each one of you what is really just a small token of appreciation for your work here. Certificate of appreciation. I think a few of you served before, if I remember. And maybe you got the same thing. I don't know. I hope it's a different certificate. I don't know how long you served, but I do want to tell you all this. It is really an honor to have members of our community respond the way you have all responded and continue to respond, even as we are working out of an extraordinary period in time. You've had to make sacrifices and given your time to serve on this jury. Last week, we did the pre-qualification and then 2 days now at the courthouse. We can't thank you enough. I make these comments on behalf of myself and on behalf of all the parties. We truly honor you and thank you for doing this job. While it's mandated by law, many people don't understand the significance and don't take the job serious. And it is so important for you to continue as jurors when called and to do this job and to let people know. Hopefully this was a good experience for you, but let people know how important it is to continue to maintain this branch of government, because this is where the people speak. This is where the citizens have that control in government, is in this branch of government. And the only way you do that is by serving on a jury. So I want to thank you again, ladies and gentlemen. It's been a pleasure having you. You are at liberty again to speak with anyone if you wish about your discussions or your verdict. You are at liberty to refuse to speak with anyone. That is your prerogative. And at this point, I will now discharge you and thank you again for your service.
All right, for the jurors.
And you can follow Robert out. Okay, great.
Take your seats.
All right. Ladies and gentlemen, I want to thank you. I always welcome you to come in. Well, I'm going to go off there.